Court does call the case. People versus Sonia McLean. You got it? We clear in? Yeah, okay. All right.
You sort of get first.
Oh, hi. Sorry. Are you working?
Yes. All discovery is complete.
That's the mission. There we go.
This is B3.
There's going to be to approach, well, Mr. Brown wants to approach you, but Mr. Brown has asked me a couple times for any videos in this case. I've sent multiple emails to YPD requesting any audio or video. They've probably unresponded to. So there may or may, I don't know if there is any video or not, but my requests for any video have gone unanswered. I have no issue with setting it for a PE. If something turns up, we'll cross that bridge and get there.
You can dismiss.
Well, I realize is there a reason to believe that there is video?
Yeah.
Okay, and the people have, you requested, Mr. Brown, people have requested a YPD, and they just have not.
They're ignoring. I'm used to that, but.
I guess, Mr. Childers, to the extent that they're not, there's no response. Is that?
The response is not that there is no video, there's just no response.
Let's dive right in. Things are off to a fiery start. The courtroom is buzzing as the high-stakes case of the People versus Sonia McLean takes center stage. Tensions are rising, and the early signs suggest this trial won't be smooth sailing. The discovery process? It's already in shambles. Key emails are scattered, crucial video evidence is mysteriously nowhere to be found, and legal document requests seem to have fallen into a black hole. The level of disarray is raising serious eyebrows. One defense attorney is practically shouting into the void. He's urgently asking for body camera footage from the Yonkers Police Department, footage that could play a pivotal role. But so far, there's been no reply. The silence? It speaks volumes. The lack of response is not just frustrating, it's fueling suspicion. In a courtroom where transparency is the expectation, the quiet is deafening and deeply unsettling.
Then, if
I suppose if the court wishes, I could elevate my email to see if I email command staff, if they may respond, I don't know. It's certainly worth a shot. If we want, in an effort to keep the case moving along, I exam at the end of September, and I can continue my efforts.
well, I don't know why it's one thing if there's an issue getting discovery. This is a whole other realm.
Yeah.
Where they're not responding to a legitimate discovery request. And I'm not trying to disparage any department, but the last time I ran into this was with YPD. And I ultimately ended up dismissing the case. All right, here's what we'll do. She wants to say something with her law degree.
Yeah.
I don't think she does. The people around you are doing just fine. Okay. So here's what I'm going to do. I'm going to set so as not to impact the defendant's rights. I'm going to set the preliminary examination. Mr. Brown, prepare an order for my signature that directs that YPD is to turn over all video. I will set this examination for the 17th.
Let's call it what it is. This isn't just disorganized, it's deeply troubling. What started as procedural delays now looks more like intentional avoidance. The court isn't buying the excuses anymore. Officials asked for evidence, and what did they get in return? Silence. Total silence. Now the judge has had enough. No more leniency, no more delays. The bench has laid down a clear and final order. The Yonkers Police Department must produce every second of the requested video footage, no gaps, no edits, by September 11th, and make no mistake, this is a hard deadline. Fail to comply, and the consequences won't just be procedural, they could be serious. The court is prepared to act. The message is loud and clear. Someone may be trying to cover their tracks, and with the clock ticking fast, the truth is about to catch up with whoever's hiding it.
So I'm going to need it right away so that there's time, but that they're to turn over all video to the Washington County Prosecutor's Office by the 11th. And if they then, that will go under my signature. That way, if they then fail to do what I'm ordering them to do, then the court will take appropriate remedies.
Your Honor, from a logistical standpoint, once that order is signed, do you like for me to send that order along to YPD?
Yes, please. Preliminary examination in this matter will indicate discovery is not complete. Preliminary examination in this matter will be set in person September 17th, 2024, 9 a.m. That will be before me. And then bond will continue. Now, given all of that, ma'am, is there something you wanted to say?
She was trying to leave and go to the, get on the bus, and there was some contact, so we had to contact Pittsfield Police to make a narrative report that she was not in violation of any court orders. I have a copy of it if you'd like.
Hold on.
Just like to be able to get on the bus.
Hold on. You gotta catch me up because that was today.
No, that was the last time. 22nd.
Here's where things stand. Let's clear the air. The preliminary hearing has been officially scheduled for September 17th. Despite the ongoing chaos around missing discovery materials, the legal process is moving full steam ahead. No delays, no extensions. For now, but then, a surprising moment shifts the room. Sonia Milan breaks her silence, stating that her contact with the alleged victim was purely accidental. Her words land heavily, catching everyone off guard and halting the courtroom in its tracks. Tension immediately thickens, uncertainty fills the air. Judges, attorneys, even spectators are holding their breath. The statement raises more questions than it answers. Intent matters, and in a case this fragile, one misstep could change everything. It's a legal tightrope, and the stakes couldn't be higher. With discovery incomplete and facts still unraveling, the courtroom is a powder keg, and it's just one spark away from detonation.
Just hold on. Okay, you're good. So, well, I just want to make sure I'm clear. You got on the bus. You were, okay, but in any event, you ended up on the bus, right? All right. Hey, but hold it, just hold it. Just hold on a moment, okay? And then at some point, the alleged victim in this case came into contact with her.
Yes.
As I'm to understand, based upon what you said, Mr. Brown, she then contacts the police.
She comes back here, asks for my advice. So
got it. That's it. I don't want to know what you two discussed. But out of that, there then is generated a report from Pittsfield.
yes,
Got it. And so your concern, ma'am, is that somehow the court may try to hold you responsible for that contact. Okay. I have not seen the report. I do not think that I need to see it. Okay. I'm going to make a presumption as to the advice that Mr. Brown gave you. I think that that was absolutely appropriate.
Let's lay it out plainly. This is how it all unraveled. What seemed like a routine bus ride quickly spiraled into a legal flashpoint. Sonia Milan boarded public transit, and so did the alleged victim. The encounter wasn't planned, but the tension between them sparked immediate concern. Within moments, the situation escalated. Authorities were alerted, a report was officially filed, and that single interaction is now a cornerstone of the case. The defense team is on edge, aware that even the slightest misstep could be interpreted as a violation of court conditions. Meanwhile, the judge remains a steady force, but there's no sign of panic on the bench. Her approach is measured, strategic, and focused purely on the facts. She's not reacting to emotion, she's tracking the law, and she's watching every move closely. This isn't just about who was on the bus, it's about intent, timing, and the fragile line between coincidence and consequence, and that line is growing thinner by the day.
And should the issue arise, then I would review that report and I would take that all into consideration. All right. But at this point, I am not going to do anything. I don't have a complaint that you've done anything. And so I'm not going to make one. Fair enough?
I need time to get on the bus again. Not leave out the courtroom and get.
Okay. All right. Listen. Just listen. Mr. Brown gave you advice, okay, regarding a situation that you had, I guess, last time that you were here, right? So it would seem to me, would it not, that should you leave and that same or similar type of thing happen, that you would then follow the advice that your attorney gave you? And I kind of indicated to you at this point how I'm looking at it. Okay? I know it may worry you, but I think follow what your attorney is telling you. All right? Okay, anything else you want to yell at me about?
I just want to have time to leave.
Not what?
I don't want to have the same issue that happened last time I was here. And you asked Ms. Morgan to stay away from work. No.
Okay, hold on. Where is Miss Morgan here?
Yes, sure.
Okay, you need to sit down.
Can I say something?
No. All right. So you need to get on the bus. Okay, stop for a moment. Miss Morgan, do you need to get on the bus?
Yeah, the bus has video, did nothing happen, I got off the bus.
Okay,
The bus has video, she's lying.
And I'm going to presume you both take the same bus.
I don't have a
Okay. I wish you would stop yelling up here at me.
Yes, sir.
Mr. Feaster?
Let's cut through the confusion. The judge has drawn a clear line in the sand. Her message was firm. If Sonia Milan and the alleged victim end up on the same bus again, it won't be seen as coincidence. It'll be treated as a serious breach. The rules are now crystal clear. Separate transportation, no exceptions. This isn't just about avoiding awkward rides. It's about legal boundaries. Taking different buses may seem simple, but in this case, it's a condition for staying within the law. The judge framed it plainly. This is about more than movement. It's about managing risk. And yes, there was a moment of levity. She cracked a light joke referencing dinosaurs and buses, but the message underneath? Stone cold serious. The courtroom may have smiled, but the warning was sharp and unmistakable. No contact. No slip-ups. No second chances. If it happens again, the court won't just take notice. It will take action. The margin for error has officially disappeared.
I'm not going to ask you to drive anybody, so don't tell me. No, I'm just, so, okay, here's the thing I do not know. And I'm going to maybe potentially embarrass myself. I have not taken a bus.
Shame on you.
Well, no, I don't, wow. Wow. But I just haven't. And so I know that when I get on a bus, or when I did, but it is just so long, the dinosaur was pulling me. But anyway, it just took me downtown, and then I had to find another bus. And I just told myself I'm not doing all that. So that's why it's my limitation. How often do the buses come to where you would have to pick the bus up, get the bus?
Every 15 minutes across the street.
Every 15 minutes across the street. Okay, so here's what we're gonna do. Okay? This time around, you get the first 15 minutes. Remind me the next time, then you'll get the first 15 minutes, and then you gotta wait and take the next bus. Huh? Oh, so now you took up all my time, now you wanna leave? No, go, just go. That's what we're gonna do. You go, don't get up, Miss Morgan, do not get on that same bus. Do not get on that. That's fine. I don't want you both on that same bus.
Still approaching me and sending threats to me, Your Honor, and that is the process.
Then you report that to the prosecutor's office. They will raise.
I'll talk to this man.
Don't know how to change it, right? Okay, so I will just say this, Ms. Morgan, when it is raised before me in a proper way by the people, I will deal with it, much like I said I would deal with her issue. But right now, I want you to take the next bus. The next time around, you'll get the first shot at the bus, she'll wait. Thank you.
Final notice. This is the last stop before real consequences. The judge made it unmistakably clear. There's no room left for informal updates or off-the-record drama. If anything new surfaces, it must go through the proper legal channels. No side talk, no surprises. The prosecution's been put on notice. They know the drill now. Follow the process, or risk disrupting the case. As for Sonia Milan, she's been ordered to keep her distance, physically and legally. No contact means no contact. Miss Morgan? She's under the same spotlight. Separate transportation, separate lives. From this point forward, they are on different tracks, and one unintentional overlap could turn this case from tense to volatile in seconds. The judge closed the session with calm, but it was the calm before a storm. One more wrong move, and this quiet courtroom could erupt with consequence. For now, the case is paused. But everyone knows, this story is far from over.